Karmelo Anthony's 35-year murder conviction has officially entered the appellate phase, but while most people are looking at his prison transfer, the real legal war is brewing over how his jury was chosen. Online platforms are completely exploding because official court records confirm that 0 black jurors were selected for the final 12-member trial panel. Advocates are calling this specific detail a flat-out travesty of justice. But what is the actual legal reality behind this challenge? Is a lack of demographic diversity enough to get a Texas murder conviction thrown out? Or did the state follow the selection rules perfectly? Today, we are keeping emotions out of this and skipping the basic appeal rules we already know. We are breaking down the exact constitutional mechanics of a jury challenge, how the selection day actually unfolded, and the strict standards the appeals court will use to grade this trial. Let's look at the facts. If you want the real facts behind the headlines, hit subscribe to U.S. Crime Cases right now. We analyze the law completely free from bias. Sit down with me for a second because we really need to look at how we got here. To understand why this appeal is happening, we have to look directly at the legal record regarding what happened in Collin County. On June 9th, 2026, a jury convicted 19-year-old Karmelo Anthony of murder. The court sentenced him to 35 years in a Texas prison. Wow, think about that for a moment. But before we get into the heavy legal mechanics, we have to remember the human lives at the very center of this case. The conviction stems from the fatal stabbing of 17-year-old Austin Metcalf on April 2nd, 2025. This happened at a high school track meet in Frisco, Texas. Right? A track meet. It is a place that is supposed to be completely normal, a place for community and family. And instead, Austin Metcalf's family lost their son. The grief that family must carry every single day is unimaginable. Court documents confirm that an altercation took place under a stadium tent, and it ended with Austin losing his life. When you hear things like that, it just stops you in your tracks. We always have to center the victims in these discussions because Austin was a teenager with his whole life ahead of him, and his family is now navigating a reality they never asked for. I see so many people forgetting that there is a real family grieving here when they argue online. We will not do that. Following the sentencing in June, Karmelo Anthony filed a notice of appeal. He is 19 years old, facing 3.5 decades behind bars. Court filings show he also submitted something called a pauper's oath. Now, if you are not familiar with the court system, a pauper's oath is a sworn legal document where a defendant declares indigency. It basically means he is telling the court, I have absolutely no money. By filing this, he waives certain legal fees, and he formally requests the court to appoint an appellate attorney for him because he cannot afford to hire his own. The court has to review his financial status, and if it is verified, the state steps in to provide legal counsel. It is a fundamental right in our system, ensuring that even if you are entirely broke, you still get a chance to have a higher court review your conviction. But right now, the main focus of public scrutiny is not actually the evidence that was collected from the track meet. It is the mechanics of the courtroom itself. The case carries intense racial dynamics. Karmelo Anthony is black and Austin Metcalf was white. And when you look at the official court documents, they show that no black jurors were selected to serve on the final panel. 0. Out of the entire community, not a single black person sat in that jury box to decide this young man's fate. When you hear a detail like that, I know what your first thought probably is. Online commentators and civil rights organizations are arguing that this lack of representation automatically makes the trial unfair. People are asking how you can have a jury of your peers if nobody on the jury shares your demographic background. It is a very raw, very real question. But to analyze this without online speculation, without jumping to conclusions or creating lies, we have to understand how a jury pool is built from the ground up. I see people assuming that the court just handpicks people to rig a specific outcome, right? Like there is a back room where they decide who gets to walk through the doors. But that is not how it actually happens. By law, the county clerk uses automated software. This computer program pulls random names from local voter registration databases and driver's license records. If you live in the county and you drive a car or vote, your name is in that massive digital bucket. This ensures the initial group of people called to the courthouse is structurally random. The court said this is the most neutral way to gather citizens. For this specific trial, Collin County sent out summons and gathered nearly 600 prospective jurors. 600 people. Think about the logistics of that. Hundreds of everyday citizens putting their lives, their jobs, and their families on hold to walk into a courthouse. From that large randomized group, the court had the massive job of narrowing it down to seat just 12 main jurors and 6 alternates. So you have 600 people and you have to get down to 18. The fact that the final 18 people included 0 black jurors has led to heavy, heated online debate. Advocates are incredibly frustrated, pointing at those numbers and saying the math just does not add up to a fair process. However, the appellate court does not rule based on public sentiment. They do not look at Twitter or TikTok to decide if a trial was constitutional. They rule strictly on the mechanical process of jury selection. In the legal world, they call this phase voir dire. Let me tell you how voir dire actually works, because it is fascinating and a little bit ruthless. During this phase, lawyers do not just randomly pick the people they like. Instead, they actively remove the people they do not want. It is a process of elimination. You sit in a room and the attorneys ask you questions. They want to know your background, your thoughts on certain laws, and if you have any personal experiences that might sway your verdict. Under Texas law, both the prosecution and the defense are granted a specific number of what they call peremptory strikes. A peremptory strike is incredibly powerful. It allows a lawyer to eliminate a potential juror from the pool without having to state a legal reason. They do not have to prove to the judge that you are biased. They do not have to give any explanation at all. If the prosecutor or the defense attorney looks at you and simply gets a bad feeling about how you might vote, they can use one of their peremptory strikes and send you home. Just like that, you are out. This exact mechanism, the peremptory strike, is where the core legal conflict of the Karmelo Anthony appeal is located. This is the dark secret of how juries are really made. Defense attorneys were sitting in that Collin County courtroom watching the process unfold. According to the court record, they saw the prosecution use their final peremptory strikes to remove the remaining qualified black jurors from the pool. Imagine sitting at the defense table and watching that happen. You are fighting for your 19-year-old client's life, and you see the last few black potential jurors being told to leave the room. Like I said, you can legally strike a juror for almost any reason. You can strike them because of their job. You can strike them because they crossed their arms and looked defensive. You can strike them based on how they answered a single question on a paper form. The law gives lawyers a massive amount of freedom to shape the jury box, but there is one major, massive exception to this rule. Back in 1986, the U.S. Supreme Court established a strict boundary in a landmark case called Batson v. Kentucky. The Supreme Court looked at how lawyers were using these free strikes and realized it was being abused to keep minorities off juries. So the Batson rule was created. This rule states in no uncertain terms that it is unconstitutional for a prosecutor to use a peremptory strike to remove a juror solely based on their race. You can strike someone for wearing a weird hat, but you absolutely cannot strike them just because they are black. When Karmelo Anthony's defense team realized the final black jurors were being dismissed by the state, they did not just sit quietly. They knew the rules. They formally objected on the official court record. They stopped the proceedings, looked at the judge, and initiated what the court calls a Batson challenge. They told the court right then and there that they believed the prosecution was crossing a constitutional line. And the moment a defense attorney says those words, the entire trial freezes, and the judge has to demand answers. So the moment a defense attorney says the words Batson challenge, the entire trial just stops. It is like someone hit the pause button on everything happening in the room. The jury selection halts. The breathing in the courtroom changes. When a defense attorney files this challenge, the judge must follow a strict 3-step legal test to figure out what is really going on. This is exactly what happened in Judge John Roach Jr.'s courtroom. It is a heavy moment because you are essentially accusing the state of doing something unconstitutional right out in the open. Step 1 requires the defense to show that the prosecution's strikes appear to be based on race. The defense lawyer has to stand up, look at the judge, and point out a clear pattern. They say, "Look, Judge, they are only striking black jurors." Once the defense makes that claim and puts it on the official record, Step 2 shifts the heavy burden entirely over to the prosecution. The state must stand up in front of everyone and provide a clear race-neutral reason for why they dismissed those specific individuals. They cannot just say, "We had a bad feeling about them." They have to give a concrete reason that has absolutely nothing to do with the color of their skin. Finally, Step 3 requires the judge to look at the prosecutor's explanation and decide if it is genuine or if it is just a cover for racial bias. It is a massive call to make, right? It all comes down to the judge's interpretation of the law and the reality of the moment. According to the trial transcripts, the prosecutors provided their race-neutral explanation to the court. The state argued that their decision to strike these specific jurors had absolutely nothing to do with race and everything to do with their professions. Prosecutors stated on the record that the dismissed individuals worked in education. Now, if you are not familiar with how this works, you might wonder why being a teacher would get you kicked off a jury. Well, the state got very specific. They pointed out that at least one prospective juror was an educator employed by the Frisco Independent School District. This is the exact school district where the fatal stabbing took place. Prosecutors argued that an educator working in that specific district might carry inherent biases about the incident or the students involved. They told the court that a teacher in that district might know the kids or might know other teachers who taught the kids. They might have heard rumors in the teacher's lounge or felt the emotional shockwave that hits a school when a student is killed. Because of this, the state argued there were serious doubts about their ability to remain completely impartial during the trial. Wow, I see how they built that argument. They framed it entirely around the location and the job, completely removing race from their stated reasoning. They made it about the community impact. Judge Roach listened to both sides. You have to imagine him sitting up there on the bench, weighing the constitutional rights of the defendant against the state's legal right to use their strikes. He evaluated the prosecution's reasoning about the jurors' ties to the local school system. He had to look at the facts presented to him, and after hearing both sides, he accepted the explanation as a valid, race-neutral justification. The court officially overruled the defense's Batson challenge, and the peremptory strikes were allowed to stand. The judge said the state gave a good enough reason under the law, and that was the final word in that room. This resulted in the final jury composition where no black jurors were seated. Civil rights groups point to this exact moment as the reason the system is flawed. They are arguing that allowing these strikes to stand stripped Karmelo Anthony of his constitutional right to a jury of his peers. They feel that the system allows lawyers to find loopholes to get the exact jury they want, even if it leaves the panel looking completely different from the community it represents. But under the letter of the law, the trial judge followed the procedural steps. The court looked at the rule book, checked the boxes, and moved forward. If you haven't subscribed to U.S. Crime Cases yet, please hit that button right now. Join our community as we uncover more legal truths today. With the jury seated, the trial moved forward, and the courtroom had to face the grim reality of what happened that day. During the trial itself, that seated jury was presented with two entirely different versions of what happened under the stadium tent at the track meet. Both sides agreed on one terrible fact: a physical altercation occurred. But the legal definitions of that altercation were completely opposed. This is where the human element really hits you. You have a track meet in Frisco, Texas. It should be a day of sports, competition, and family. It is a place where teenagers are supposed to be safe. Instead, it became a crime scene. According to the defense, Karmelo Anthony acted in self-defense. Defense attorneys argued that Austin Metcalf initiated the first physical contact. They told the court that Metcalf grabbed and shoved Anthony under that tent. They argued that this physical contact caused Anthony to react with a knife out of fear for his own safety. The defense tried to show the jury a 19-year-old who was scared, who felt backed into a corner, and who made a tragic split-second choice to protect himself from an immediate physical threat. They wanted the jury to understand the panic of that moment and see it as survival, not murder. But the state had a completely different story. According to the prosecution, the stabbing was an unprovoked sneak attack. Prosecutors stated in court that Anthony intentionally provoked the physical incident. They told the court that he deliberately stabbed the unarmed Metcalf in the chest. They argued it was not fear, but aggression. They painted a picture of a 17-year-old boy who was caught off guard, who had no weapon, and who was violently attacked in a place where he should have been safe. The jury had to listen to these two competing stories and decide which one was the truth. They had to weigh the life of the victim against the intent of the defendant. It is a heavy burden to place on 12 people. The jury made their choice, rejecting the self-defense claim and handing down the 35-year conviction. Following the conviction, both families spoke publicly, and their statements reflect the permanent damage left by the incident. This is the part that always gets me. The legal mechanics are fascinating to study, but the human cost is just devastating. We can talk about Batson challenges and jury pools all day, but at the end of it, a young man is dead and another young man is spending decades in prison. Kala Hayes, Anthony's mother, spoke to CBS and maintained her son's defense. She stated that her son didn't mean to hurt anyone and that he was defending himself. Right. You can hear the pain of a mother who's watching her teenage son being taken away in handcuffs to a Texas prison. She still believes in his side of the story, as any mother probably would. It is a different kind of tragedy for her family. They are losing a son to the system, and they firmly believe he was just trying to survive. On the other side, you have Jeff Metcalf, Austin's father. He spoke about the heavy burden of the aftermath. Wow. The grace it takes to speak after losing your 17-year-old son to violence is hard to comprehend. He told reporters that forgiveness was for him so he would not have to carry rage and hate for the rest of his life. He chose not to let the anger destroy him, while still emphasizing that nothing brings his son back. Austin is gone. And no matter what happens with the appeals, no matter what a judge decides about the jury selection, that cold fact does not change. His family has an empty seat at the dinner table that will never be filled again. These statements show the cold, hard reality of the families involved. The grief is permanent on both sides. But as this case moves forward into the appellate courts, the judges will not use emotion to decide the next step. The law is blind to the tears of the mothers and the fathers. The appellate court will rely entirely on the written record of what happened during that jury selection. They will read the transcripts of what the prosecutors said and what Judge Roach ruled. They will not interview the families, and they will not look at the tragedy of the track meet. They are just checking the math of the law to see if it was done correctly. We will continue to follow the facts of this appeal as they come in. As this case moves higher up the legal chain, we have to look at how an appeal actually works. I talk to a lot of people about the justice system, and I see so much confusion about what happens after a guilty verdict is handed down. A lot of online speculation assumes the appellate court will just retry the case from scratch. People picture this grand, dramatic scene. They think the higher judges will call all the witnesses back into the room, lay out the physical evidence from the track meet on a table, and re-examine everything. Some people even think the judges will bring in the original jurors and interview them one by one to see if they were actually biased or if they made a mistake, right? That is what we are trained to expect from movies, but that is completely false. That is not how an appeal functions in real life. Appellate judges do not hear new testimony. They do not talk to the police who respond to the scene, and they do not look at the weapon. The reality of an appeal is actually incredibly quiet, dry, and heavily administrative. These judges sit in offices far away from the emotional weight of the trial court, and they read paper transcripts. Their only job is to review the exact written record of the jury selection day. They look at the words typed out by the court reporter, line by line, page by page. They are doing this for one specific reason. Their goal is to determine if Judge Roach made a legal error when he accepted the prosecution's race-neutral explanation for striking the black jurors. They are not trying to decide if Karmelo Anthony was acting in self-defense or if it was an unprovoked attack. That part is over. They are strictly looking to see if the rules of the courtroom were followed correctly on that specific day during voir dire. It is a strange thing to think about. The fate of a 19-year-old young man and the closure of a grieving family all comes down to judges reading a stack of papers to check the procedural math of the trial judge. This brings us to a major point of debate online. And there are distinct risks and good news depending on which side of the case you look at. We have to view this through the lens of both families because they are currently living through completely different legal nightmares. For the followers of the victim, Austin Metcalf, and for his family trying to navigate life without their son, the state's position is highly insulated. When you lose a family member to violence, surviving the trial is incredibly traumatic. You have to sit in a room and listen to strangers debate the last moments of your child's life. Once a conviction happens, families usually just want the legal process to stop so they can focus on healing. For the Metcalf family, the structure of the law provides a shield. The danger of an automatic reversal is low because the trial judge already vetted and approved the jury strikes on the record. The appellate court generally defers to the trial judge who was physically in the room to evaluate the prosecutor's credibility. Think about why the court does this. Judge Roach was sitting right there on the bench. He could look the prosecutors in the eye. He could hear the tone of their voice, see their body language, and gauge their sincerity when they said they were striking those prospective jurors because they were educators in the Frisco Independent School District. The appellate judges reading a cold piece of paper months later cannot see any of that human context. So the law dictates that they must trust the trial judge's assessment unless there is clear, documented misconduct uncovered in the transcripts. Unless the transcript proves the judge blatantly ignored a constitutional violation, the appellate court will likely let the decision stand. This deference gives the state's conviction a massive layer of protection, which in turn protects the Metcalf family from the immediate threat of having to endure another grueling trial. Wow, you can only imagine the heavy relief that brings to a family just trying to find some peace. However, for Anthony's followers and his family who are hoping for a total trial reset, winning this specific challenge carries a massive hidden danger. I do not think the general public really grasps the terrifying risk involved in an appeal like this. People online act like if the appellate court agrees the jury selection was flawed and the Batson challenge should have been upheld, the judges will just apologize to Karmelo Anthony and let him walk free out the front doors of the prison. I see comments like that every day, but they do not let him walk free. That is not how the system works at all. If Anthony wins this appeal, they throw out the conviction entirely. It gets erased from the books. But then they send the case right back down to Collin County for a brand new trial. They reset the clock back to zero. The prosecution will gather their evidence, a new randomized pool of citizens will be called to the courthouse, and the grueling process of jury selection will start all over again. But here is the brutal catch that his defense team has to weigh. A second jury will not be bound by the original 35-year limit. When that first conviction is thrown out, the original 35-year sentence vanishes with it. This means if the state tries him again and a new jury listens to the evidence and finds him guilty of murder a second time, Anthony could face a significantly harsher sentence. Under Texas law, he could face up to 99 years or life in prison. I see. Think about the psychological weight of that reality. You are 19 years old. You are already facing 3.5 decades behind bars. You feel your jury was selected unfairly, so you fight back. Fighting a conviction is a constitutional right, but it resets the entire board, including the penalties. It is an unbelievable gamble. You are essentially risking the rest of your natural life on the hope that a second jury will either acquit you or give you a lighter sentence. If you lose everything. You could walk into that second trial with 35 years and walk out with a life sentence. His legal team had to explain this risk to him. His mother, who just wants her son safe, has to live with the anxiety of knowing that fighting for a fair jury could ultimately put him away forever. It is a high-stakes legal tightrope, and there is no safety net if they fall. This leaves us with highly important questions to discuss regarding how the justice system operates. When we step back from the intense emotions of the track meet and look strictly at the mechanics of the law, we have to ask ourselves what true fairness looks like in a modern courtroom. From a legal standpoint, should the constitutional standard for a fair trial be satisfied by a completely randomized selection pool? The court said that pulling names from a computer program is the most unbiased way to gather citizens. But is randomization enough to guarantee a fair trial? Or should the final 12-member panel be structurally required to mirror the specific demographics of the local community? If a community has a certain percentage of Black residents, should the law mandate that the jury box reflects that exact percentage? We have to decide if a jury of your peers means people chosen at random or people who share your lived experience. Furthermore, we have to look closely at the power we give lawyers during voir dire. Do automated peremptory strikes, which allow lawyers to eliminate jurors without giving a reason, help ensure a fair panel? The system argues that these strikes are necessary so lawyers can remove people they suspect might have hidden biases, even if they cannot explicitly prove it. But do they inadvertently allow those exact same hidden biases to influence the final composition of a jury? If a lawyer does not have to state a reason for sending a citizen home, how do we ever truly know that the process is completely blind and fair? Is the Batson rule enough to catch discrimination, or is it too easy for lawyers to just find a race-neutral excuse, like a person's profession? Finally, knowing the extreme human cost involved, and knowing that a successful jury selection appeal triggers a completely new trial where a defendant faces a potential 99-year maximum sentence, is pursuing this specific challenge a smart legal risk or a highly dangerous gamble? If you, in his position, looking at 35 years, would you accept the time, or would you risk a life sentence to fight what you believed was an unconstitutional jury selection? It is a question that tests your faith in the system. Let me know your thoughts on jury selection rules in the comments below. Keep the conversation focused strictly on court policy and how we can improve the laws that govern us all. Thank you so much for staying with me until the end. Hit subscribe to U.S. Crime Cases for more updates, and I'll see you soon.